Welcome to our presentation about intellectual properties and the case Performing Rights Society Limited versus Francis Anthony Hickey, the owner of the barbecue drive-in restaurant in Zambia, Africa. Presentation is going to be held by Florian Weinhardt.
And Francesca Yivartega.
Let's start right away. Facts about the case. The Performing Rights Society Limited hereinafter plaintiff is a society which aims to protect the copyright of music, artists, composers, in exchange for fees. In the early 1975, the plaintiff conducted investigations on a barbecue drive-in restaurant located in Africa. At this time, the restaurant or bar was under the ownership of Francis Anthony, hereinafter defendant. The defendant used to organize weekly dance events at his inn and played several songs such as Kung Fu Fighting, House of Exile, and Money Won't Save You, which are under the copyright protection of the plaintiff. In September and October of 1975, the plaintiff sent 2 letters to the defendant informing him that he was violating the copyright of the songs. The defendant ignored those letters, and the case was forwarded from the plaintiff to its solidors, while some more physical investigations took place on site. On the 8th of December 1978, the court in Lusaka processed the case, in which the plaintiff wanted to prohibit the defendant to play music of the songs mentioned above and claim damages as well as lost profits. Now Francesca is going to tell you a little bit about the facts about copyrights.
To the definition of copyrights. The copyright is a statutory right. That means it has a copyright license what authorize a third party to use the copyright work in exchange for a fee. The statutory right that gives an author of an artistic work the copyright for a limited period was mostly for 50 to 70 years. It has an exclusive privilege of making copies and publish and sell the work. The copyright holders join the right of moral rights and pecuniary rights. So we go further to the problem. The main problem in this case is that the defendant used a work what was protected by copyright. The defendant even continued playing the music after he received more than 1 letters requesting him to stop playing the music or get the proper public performance license, how it is written in the law. The court should, our opinion, determine whenever 2 points. The defendant violated copyright law and his need to get public performance license, and that the plaintiff is after law entitled to damages or lost profits. The relevant law and regulation will Florian explain shortly.
Due to the fact that there was no national law about the copyright violations, the law of the UN or like the USA was used in this case, which is the Chapter 701 and the Section 33 of the Copyright Act, which regulates the identification of copyright violations and exemptions, respectively mitigating circumstances of the copyright violations if no reasonable grounds for the suspect are given. Theory in 701 states that any person who does or causes any person to do so to use somebody else's intellectual property without their permission or license violates the copyright. Section 13.3, however, states that if the copyright has been violated but the defendant was not aware about this violation, then the plaintiff shall not be entitled to any damages but shall be entitled to lost profits.
With this we go further to our reasonings and solutions. The argument by the plaintiff is that the defendant was asked multiple times with a written letter to stop playing the music or get a proper license, how it is written in the law for the copyright. The owner or plaintiff is authorized to give a third party to use the copyright, but just in exchange for a fee. Secondly, the defendant nevertheless continued playing the music and ignored the requests. our arguments by the defendant are that he was totally unaware of what he's doing. He did not knew that there are copyrights even existing for playing music in the restaurant. Yeah, he was unaware of the additional property sorry again. The defendant brought the records and was unaware of the additional proper public performance license. And additionally, the defendant was not substantiated with any acts or locally decided cases in the letter that was sent by the plaintiff. The defendant thought that the letters would be a scam and did not see any connection between the music and the letters. In his understanding, copyright only related to reproducing the item in question. Further, we go to the court decision.
The court concluded that the defendant was not fully aware of his violations of the copyright. Therefore, after Section 13.3, the judge did not hold the defendant responsible for damages, but for loss of profits. In addition to that, the defendant was prohibited from any further copyright violations in terms of music. This case was a milestone in the copyright violation sector. However, the same law is nowadays not applicable anymore. Thank you very much for your attention and watching our presentation, and enjoy your day.
Thank you very much.